Put up the sedition act for them, please. Let them see.
Series. This episode is about explaining sedition. Welcome to our Rule of Law and Good Governance series. This episode is about explaining sedition. Recently, in Trinidad and Tobago, the term sedition was used in the public domain. It has subsequently become the subject of much public discussion. Here, we will explain the sedition laws as well as clear up any confusion with sedition and treason. We make reference to the Sedition Act, number 10 of 1920 and its amendments in 1961, 1969, 1971, and 1976, and the Treason Act, number 16 of 1842 and its amendments in 1979. Seditious acts can come through several forms including publications, for example, newspapers and periodical publications, as well as through statements. Statements are words spoken, written, or recorded, as well as signs or other visible representations. It is very important that seditious intent be proven to get a conviction. What does this include? First, seditious intent brings hatred or contempt, or excites disaffection against the government, the Constitution, Parliament, or the justice system. Second, seditious intent is an intention to excite someone to attempt to use unlawful means to alter situations that were presented to them. Third, it can have the intent to raise discontent or disaffection among persons living in Trinidad and Tobago. Fourth, seditious intent can engender or promote the following two emotions. A. Feelings of ill will or hostility between one or more sections of the community. B. Feelings of ill will towards, hostility to, or contempt for any class of persons in Trinidad and Tobago that are distinguished by race, color, religion, profession, calling, or employment. Fifth, seditious intent can promote with intent the destruction of identifiable groups through the commission of any of the following. A. Killing members of the group. B. Deliberately inflicting on a group conditions of life to bring about its physical destruction. Now, we see the wide range of seditious intent from raising up emotions to killing persons. However, the following legal provision is critical to note. An act, speech, statement, or publication cannot be deemed seditious by reason if it intends to A. Show that the government has misled or is mistaken in its measures, or B. Point out errors or defects in the government or Constitution. Further, if the sharing of material through publications or statements is done with the intent to reform or fix the problem or even to excite persons to take lawful means to change these situations that were causing feelings of ill will, hostility, or contempt between sections of the community or classes in Trinidad and Tobago, then it cannot be classified as seditious. In addition, the law also provides for persons who may have seditious material and did not know that it was seditious, they cannot be convicted of sedition as well. The law stipulates that if a person commits or attempts to commit a seditious act in the various forms identified earlier, if such a person received a summary conviction, usually by a magistrate, he gets a fine of $3,000 and 2 years imprisonment. If he receives a conviction on indictment, usually by a judge and jury in the High Court, he gets a fine of $25,000 and 5 years imprisonment. Did you know that if the President of Trinidad and Tobago is of the opinion that any publication or statement is seditious, she may issue an order to prohibit it from coming into the country? If anyone imports, prints, publishes, copies, reproduces, communicates materials that are listed as seditious upon summary conviction, he receives a fine of $10,000 or 3 years imprisonment. If he is convicted in the High Court as an indictable offense, the punishment is 5 years imprisonment. There are some safety provisions in this law. For example, A. No person shall be prosecuted without the written consent of the Director of Public Prosecutions. B. No person shall be convicted on the uncorroborated testimony of one witness. C. A person can also be prosecuted under the common law or any other act, but he shall not be punished twice for the same offense. We have heard persons likening sedition to treason. There is a major difference. Treason is where any person owing allegiance to the state who, whether in Trinidad and Tobago or elsewhere, A. forms an intention to levy war against the state or to overthrow the government or the Constitution by force and uses overt acts, and b. adheres to the enemies of the state by giving them aid or comfort. The punishment for treason in Trinidad and Tobago is the death penalty. Note the vast differences in penalties for treason and sedition. Where can someone find a list of publications classified as seditious? These are listed in the legislation. In fact, there is a prohibited publication order where these are itemized. In the past, some of the prohibited seditious publications in the Caribbean include the Caribbean News Quarterly, West Indian Clarion, West Indian News, Caribbean Challenge, Caribbean Gazette, Caribbean Advocate, Caribbean Review, and Guyana Information Bulletin. Some of the international publications that were prohibited and deemed seditious were the Marxist Quarterly, World Marxist Review, and the Carib. Section 1 of the Constitution of Trinidad and Tobago provides that Trinidad and Tobago shall be the sovereign democratic state. Is it consistent with this constitutional guarantee that the law criminalizes any speech which has a tendency to excite disaffection against the government of Trinidad and Tobago, or raise discontent among its inhabitants? On Tuesday, June 20th, the Privy Council was asked to decide whether the Sedition Act, a colonial-era law first enacted in 1920, is consistent with the Republican Constitution of 1976 and its guarantee of a democratic state. A second question is whether, to the extent that the Sedition Act infringes the fundamental rights protected by Section 4 of the Constitution, it is saved as existing law by Section 6. The Privy Council was asked whether the judge at first instance was right to find that the Sedition Act was so dangerously broad and uncertain that it lacked the quality of law and therefore was not saved as existing law. The case was Maharaj and Central Broadcasting Service Ltd versus Attorney General of Trinidad and Tobago. Peter Knox KC and Robert Strang acted for the appellants, along with a team of attorneys from Trinidad, Senior Counsel Ramesh L. Maharaj, leading Keel Taklalsingh, Dinesh Rambali, and Stephen Ramkissoon. In November 2023, the Privy Council ruled Trinidad and Tobago's sedition laws stand as it dismissed the Sanatan Dharma Mahasabha (SDMS) challenge to the constitutionality of the pre-independence legislation. The SDMS had challenged the lawfulness and constitutionality of certain provisions of the Sedition Act, particularly Sections 3, 4, and 13, which it said were vague, uncertain, and therefore illegal. Section 3 sets out what is considered a seditious act, while Section 4 details the particulars of the offenses and Section 13 deals with search warrants. In 2020, after Judge Frank Seepersad upheld the SDMS challenge, the Office of the Attorney General successfully applied for a stay of the judgment to protect two pending matters being prosecuted by the Office of the DPP, one of which was the sedition charge against Jamaat al-Muslimin leader Yassin Abu Bakr. Bakr died in October 2021.